You showed up to work on a Monday morning just like any other day. You grabbed your coffee, you sat at your desk, you logged in. Then your manager called you into a small room you had never been called into before. HR was already sitting there. They slid a piece of paper across the table. Effective immediately, your employment is terminated. No warning, no write-up, no explanation that made any sense. And just like that, after years of showing up, working hard, and doing everything right, you were out. Now here is the question nobody tells you the answer to. Was what they just did to you actually legal? Because what most people do in that moment is pack their things and walk out. They assume the company had the right to do it. They go home, they feel humiliated, and they never push back. But here is what the law actually says, and it might change everything you thought you knew. In the United States, most employees fall under something called at-will employment. This means your employer can fire you at any time for any reason or for no reason at all. That sounds brutal. And it is. But here's where it gets interesting. At-will employment has limits, and those limits are where your rights begin. Even in an at-will state, your employer cannot fire you for an illegal reason, and there are more illegal reasons than most people realize. They cannot fire you because of your race, your gender, your age, your religion, your disability, or your national origin. That is federal law under Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act, and the Americans with Disabilities Act. These are not suggestions. They are hard legal protections. And there is more. They also cannot fire you for reporting illegal activity in the workplace. That is called whistleblower protection, and it is covered under multiple federal statutes. If you reported something and then suddenly found yourself in that small room with HR, that timing matters. Courts look at that timing very carefully. They cannot fire you for taking legally protected leave. If you were on medical leave, family leave, or military leave, and they let you go during or right after that leave, that is potentially a violation of the Family and Medical Leave Act, and they cannot fire you for organizing with other employees or discussing your pay. That right is protected under the National Labor Relations Act, and most employees have no idea it even exists. So what do you do? First, do not sign anything they hand you in that room without reading it carefully. Many termination agreements contain clauses that waive your right to sue. They will tell you it is standard. It is not always in your favor. Second, write down everything you remember about that meeting the moment you leave. The names of everyone in the room, the exact words that were used, the time, the date. This becomes your evidence. Third, request your personnel file. In most U.S. states, you have a legal right to access it. Look for any documentation of poor performance. If there is none, that is significant. Now here's the part that surprises most people. Even if you were fired legally, even if the company did everything by the book, you may still be entitled to compensation. If your company had a written policy about progressive discipline, warnings before termination, and they skipped that process entirely, you may have a breach of contract claim. That policy, whether it is in an employee handbook or a signed agreement, can be treated as a contract. That small room with HR might not be the end of your story. And here is one more thing most fired employees never think to check. If your employer promised you something, a bonus, a commission, a raise, and then fired you right before it was due to be paid, that could be wrongful termination, motivated by financial gain on their part. Courts have seen this before, and employees have won. Here is something most people do not know exists. There is a federal agency called the EEOC, the Equal Employment Opportunity Commission. Think of them as the government's way of saying, we are watching. You file a charge with them, it costs you absolutely nothing. And suddenly your former employer is not just dealing with you anymore. They are dealing with the federal government. A lot of cases never even make it to court after that. Companies settle. Quietly. Quickly. You have 180 days from the date of your termination to file. In some states, that window extends to 300 days. That clock is already running. Here's what most people never do. They walk out of that room, they feel powerless, and they move on. But the law did not move on. The law was sitting in that room with you the entire time. You had rights before they called you in. You had rights while they were talking. And you have rights right now. The people who come out of wrongful termination situations with something are not always the ones with the best lawyers. They are the ones who knew their rights quickly enough to act on them. Now you do